This is a special report from True Crime Today and the Hidden Killers podcast.
I'm Tony Bruschi. Thanks for joining us. Let's go back to the courtroom now for the September 14th hearing of Alex Murdaugh.
Yes, sir.
May it please court, Your Honor, we're here on the State versus Corey Fleming. Mr. Fleming is present with his counsel, Debbie Barbier and Nathan Williams. As Your Honor is aware, back on August 23rd, 2023, Mr. Fleming pled guilty to all the state grand jury charges against him. Those are 23 separate charges. Just very quickly to detail those. The first one is 2021 GS 4730, which was indicted by the South Carolina State Grand Jury in March of 2022. And that alleges 18 counts against Mr. Fleming for victimization of Gloria Satterfield's estate and ultimately her sons as beneficiaries of that estate. And I would point out that we do have representatives of the Satterfield family here today, as well as their counsel, Eric Bland. And I believe some of the victims want to address the court at the appropriate time. Your Honor, we also have State Grand Jury Indictment 2022 GS 47-2. That was indicted by the South Carolina State Grand Jury in April of 2022. And that alleges 5 counts against Mr. Fleming. And that is where the victim is Ms. Pamela Pinckney. And we have here Representative Ms. Pinckney, Justin Bamberg, who's here. Ms. Pinckney wanted to attend, was unable to make it, but Mr. Bamberg will be speaking on her behalf here today. Your Honor, I'd like to, I know we went through a very extensive factual basis and put in a number, over 20 exhibits at the plea. And as I described it at the plea, I think that the issue here is if we were in traffic court and the speed limit was 55 and Mr. Fleming wants to say, well, I admit I did 58, and the state, if I'm the trooper, I'm like, no, Your Honor, we clocked him doing 90. Weaving in and out of traffic like a video game. And so what I'd like to do, Your Honor, with the court's indulgence is just kind of detail some of the facts that show the true and real extent of the conduct here, because again, it does go to the heart of the state judicial system. Your Honor, these allegations here involve the use of state law licenses in state court actions before state judges with state court approved settlements. So ultimately, Mr. Fleming has admitted to a violation and abuse of the state judicial system. And because of that, Your Honor, I would submit to the court that the state judicial system must defend itself. It must provide its own accountability for those who would abuse it. And that is what the state, and I believe the victims, will be asking Your Honor to do here today. Mr. Fleming admits that he conspired with Alex Murdaugh to steal money in both the Pinckney matter and the Satterfield matter. He admits that, Your Honor. He admits to colluding with Mr. Murdaugh in the Pinckney matter when he was recruited by Mr. Murdaugh to represent Ms. Pinckney because she was a driver in the crash, but also a plaintiff, and so they needed another lawyer involved in the case. Mr. Murdaugh represented the other clients, including Hakeem Pinckney. And in the Satterfield matter, as Your Honor has heard, Mr. Murdaugh recruited, put these cases in Mr. Fleming's lap. In the Satterfield matter, where Mr. Fleming was going to represent the estate and represent the sons of Miss Gloria Satterfield, but Mr. Fleming was going to behind the scenes collude with the defendant in that action. Not the attorney, but the defendant himself. And what Mr. Fleming, I think, wants the court to believe is even though the state grand jury, he initially reported to everyone that he was a victim of Mr. Murdaugh just like everybody else. Just like Mr. Murdaugh's law partners and just like his clients, he was tricked and fooled by Mr. Murdaugh just like anyone else. But what happened was the state grand jury, which again is a partnership of the Attorney General and SLED, and the people sitting around me and the SLED agents over there, right out of the gate, when we first got involved in September of 2021. And one of the things that we uncovered was that Mr. Fleming had been stealing checks from his clients going all the way back to 2012. All the way back to 2012. So when Mr. Fleming tries to tell this court that, okay, I stole a little bit, but I really was hoodooed by Alex Murdaugh as to the big money, I'd ask the court to consider that and consider this entire chain of conduct and whether or not that makes common sense and whether or not that fits with the evidence. Your Honor, what we see at the beginning of this case, the Pinckney wreck occurred back in 2009. And it resulted in terrible injuries to members of that family, injuries that ultimately contributed to Hakeem's death, injuries that Miss Pamela Pinckney, is still dealing with to this day. And what the evidence revealed is that Mr. Fleming knew how to interact with his clients. Early on, he's interacting with Miss P. He's developing that personal relationship with Miss P that you expect a lawyer to do in a case like this. He knows how to do it. But then what we see is at the same time where he's telling Miss P he's taking care of her, he's spending time with her, he's going to her hospital bed. It doesn't take him long to steal a couple of checks so that he and Alex Murdaugh can fly in a private plane and go to the College World Series. And he bills that. No one else did this. This is in his records from his law firm. He bills that to Crosswind as if it is a medical expense. And it was a private plane ride to go party with Miss P's money. And so when Mr. Fleming tries to tell you that he didn't really know what was going on throughout this entire decade-long scheme of conduct, I would ask Your Honor to take that into consideration when you look at what he really did and how long it's been going on. He dispersed a large sum of money to Miss Pinckney the right way. And there is no better feeling, I am told, for a plaintiff's lawyer or their staff that when they get to call in that person who's been hurt, who's suffered, and say, I know you've been hurt, I know you've been suffered, but I've got a check of life-changing money for you. Here it is here today. And in fact, that's how usually the scheme works, because those clients, those victims are so distracted by the big check in front of them that they're not paying attention to the sleight of hand behind them. And that's what Mr. Fleming did with his law license. Mr. Fleming stole those Crosswind checks in 2012. And one of the facts I have to reiterate for Your Honor is we mentioned another civil action in which Mr. Fleming was not actually the defendant, but he pretty much was the defendant because it was a close family member who was the defendant. And what the investigation revealed was that Mr. Fleming, as essentially the defendant, was doing the legal work in the case, and they were essentially using Alex Murdaugh's name as the plaintiff's lawyer. To the point where there is an email where Mr. Fleming sends to Alex Murdaugh's staffer the petition and the order with the settlement in there and says, hey, I need you to send it to the defense lawyer so it doesn't look like it came from me. And this man wants to try to convince you that he didn't really know what was up in his dealings with Alex Murdaugh. Ultimately, in that case, Your Honor, the order that was submitted, the settlement, reflects $48,000 in legal fees that were supposed to go on the paper to Alex Murdaugh. But instead, they ended up in the pocket of essentially the defendant and his family. And that's ultimately how the state grand jury figured it out, because we saw this $48,000 reference, but no $48,000 check coming into the PMPED law firm. But does it sound familiar, Your Honor? Again, I would ask you to consider that it was essentially Satterfield in reverse. Except this time, Mr. Fleming was the beneficiary as essentially the defendant of receiving monies that were supposedly going to the plaintiff and the plaintiff's counsel. Your Honor, that was going on 2012 through 2014, around the time that Mr. Fleming first stole from Miss Pinckney. And years go by to all the way to 2017. And Mr. Fleming still has money belonging to Miss Pinckney in his account. Money that he had retained supposedly for satisfaction of liens. But what we found, what we uncovered, was that was a perfect delta of money. Because once you settled those liens, or you just don't even settle them at all, that's money then that you can steal or steal from. And in 2017, Mr. Murdaugh cuts a check for $4,560 and delivers it to Alex Murdaugh, or causes it to be delivered for fake expenses of Miss P's money. Again, when you consider what he's trying to convince you, think about the entire course of conduct here and how these two men operated together. But more importantly, he also cuts a check for $89,000, over $89,000 of Miss P's money, and cuts it to PMP, and Alex Murdaugh promptly converts it to forge. This is a man, again, who knew how to interact with Miss P, who had interacted with Miss P, who had sat by her bedside as she suffered from the injuries of that wreck. Does he call up Miss P in 2017 and say, "Great news, I got $89,000 more of your money"? Does he call up that client that he had that personal interaction with? No. He just gives it to PMP&D, gives it to Alex. Makes no effort to contact her. Again, when we look at this entirety of these events, and Mr. Fleming tries to tell you, okay, I got caught red-handed stealing a little bit, but I didn't know about all this other stuff. It doesn't fit with the evidence. It doesn't fit with common sense. But if we had any question, and we're going to get to the 3 checks in the Satterfield matter. There were 3 checks. There were one check for over $400,000 that Mr. Fleming made out from his trust account to just the single word forge, which in and itself is ridiculous. Just the word forge. A second check for over $2.9 million. This is money that's supposed to go to this family right here, Your Honor. Made out to the word forge. And a third check for $118,000 made out to the word forge. All of that money was supposed to go to this family, and it doesn't. Mr. Fleming, I believe, wants to convince Your Honor that when he cut those checks representing the proceeds that were supposed to go to this family and caused those to be delivered to Alex Murdaugh, made out to forge, that he didn't know that Alex might take any of that money. That he thought every penny of that money was going to go to those boys. And it doesn't make sense. It doesn't make sense with the history here, and it doesn't make sense with the specific evidence in this case. And let's talk about the first thing that we have. Aside from just, it doesn't make common sense. It doesn't make common sense to make out a check just to the word forge. It doesn't make sense because forge doesn't take money in the traditional sense. It doesn't make sense because his own staff testified that Mr. Fleming did everything differently in this case. It doesn't make sense because Mr. Fleming, unlike we know how he does to do with Mr. P, never made an effort to talk to the Satterfield family. Never made an effort to find out if they got their money. Never contacted them, never called them up and said, "Great news." Never told the PR that they pretty much brought in as a patsy to do that either. Never told him what to do. And I'll talk a little bit more about that in a second, Your Honor. In December of 27, though, if we had any illusion that Mr. Fleming, when he cut those checks to forge out of his trust account, when he received the settlement money in his trust account, that that's not how you do a structure, we have that email that I detailed for Your Honor, where Michael Gunn at the legitimate forge explained to Mr. Fleming and his staffer, you received the money, we can't set up a traditional structure.
What year was that again?
That was in December 20th, 2017 was that email, and that was State's Plea Exhibit number 5, Your Honor. And I have another copy of the plea exhibits, if Your Honor. I don't know if Your Honor has them.
Yes, sir, if you would.
I'll pass those out. That was December 2017. Just a few months later, in February of 2018, Gloria Satterfield, a longtime housekeeper where the Murdaughs fell at Moselle, and suffered injuries from which she ultimately succumbed on February 26, 2018. And Your Honor's heard evidence that not long after that, Alex Murdaugh told the Satterfield family that he was going to take care of them. He was going to make sure that they got taken care of for their mother's death, for her long service to that family. And who did he bring in? His longtime co-conspirator, Corey Fleming. But Corey Fleming only met with them once or twice, if that. Met with them a couple times. He never had them sign a fee agreement, which is common practice, as Your Honor knows, required practice. He never updated the Satterfields on the status of the case. He never advised them about the recoveries. He never advised them of the settlement offers. He never advised them that money was being directed to Forge. He never, of course, told them that he and Mr. Murdaugh, as I'll detail, were dipping into their money for their own personal gain and expenses. And what's most important, Your Honor, is Mr. Fleming never told this family, never told Chad Westendorf, the PR that they put in as a patsy, what he's going to try to claim to Your Honor now, that he generously cut his fee in half and had no idea that Alec was going to take any of the other half of that fee. That's what he's tried to claim now. Cut his fee in half, and never once tells the PR that. Never once tells them that. You know what kind of lawyer I am? I'm going to cut my fee in half. $600,000 is enough for me. And why doesn't he tell them that? Because he's got an arrangement with Alex Murdaugh, and all the evidence in this case reflects it. It works out to be just like a fee split you see over and over again. And the reality is, the reason is because they co-litigated the case. Alex Murdaugh functioned as co-counsel with Corey Fleming, co-plaintiff's counsel, in a case where Alex was the defendant. It was a shakedown. Plain and simple. These boys, this family, deserve compensation. But they were nothing but a vehicle for Mr. Fleming and Mr. Murdaugh to steal money. Again, looking at common sense and what the evidence reflects. But in November of 2018, there's two policies, one for $500K, Lloyd's of London, and they pay on the policy. Well, guess what? At that point in time, Tony Satterfield is the PR of the estate. That's Mr. Fleming's client. Does Mr. Fleming call up Mr. Satterfield and say, Tony, great news, they tendered the policy limits. First check's in, $500K, $500,000. No, he does not do that at all. In fact, he, and we have the email, instructs his staff, hold this check until we can get the PR changed. Hold this until we can get the PR changed. Why in the world did he do that if he thought that that money was legitimately going to go to those boys? It's not. It was meant to put in the patsy so they could cover up what they were about to do. And the evidence is clear, Your Honor. That's State's Plea Exhibit number 6. In fact, they get the check Lloyd's of London cuts that check on December 4th, and they make it out to Chad Westendorf. He hasn't even been designated as a PR yet. They haven't even changed it yet. They already get the check made out to Chad Westendorf. And Westendorf was clear, and the evidence was clear, that he was not instructed what to do. In fact, he was always told by Mr. Fleming, I got it, I'll handle it. Do I need to do anything? Do I need to open a bank account? No, I got it. I'll handle the disbursements. That's not Alec, that's Mr. Fleming saying that, according to the evidence gathered in this case. In December of 2018, Mr. Satterfield is convinced by Alec to sign over being PR of the estate so that this scheme can take effect. And an order is filed that retroactively says the date was back in March of 2018, which is a fabrication.
What date was that again?
December 18, 2018 is when the PR change is issued. That's plea exhibit number 7. And the date in plea exhibit 7, if you look at that document, says that it was effective from March 28, 2018. Again, plea exhibit 7, Your Honor. Complete fabrication. Chad Westendorf hadn't been contacted back in March. Tony was the PR. This is all after the fact to hide what they're about to do. And so when he says he thought that check that he cut to Forge, which he cut shortly after this, for $403,000 was actually going to go to an account for those boys, aside from the fact that that's not how it works, and it makes no sense, and it's made out to a single word Forge, it's all an after-the-fact reconstruction to put in their patsy so they don't know that they've gotten a recovery. And Mr. Fleming is at the center of that. Aside from the fact that even if he tries to claim that when he handed those checks to his co-conspirator abusing the judicial system, that I didn't know what my fellow thief was going to do with it, that's not even good enough under the law anyway. When you're conspiring with somebody, you're responsible for the natural and probable consequences of that act regardless. But even that being the case, he knew, and the evidence is clear. I want to be clear. The state has never contended that Mr. Fleming thought that Alec was going to steal every single dime. Because that's not usually how the scheme works, right? As I just stated, you're usually handing some big check, life-changing money to people who've never had that kind of money before, and they're so distracted by that they don't realize you're stealing right from behind them. But for Mr. Fleming to claim that when he delivered those forged checks representing the vast bulk of all this money, that he thought that every dime was going to go to those boys, it defies common sense, it defies the evidence, it defies what he knew how things were supposed to work. Mr. Fleming never once communicates with Tony Satterfield about the change of the PR, never once communicates with Tony Satterfield about a recovery of $500,000. Instead, he deposits the check that they had pre-made out to Chad Westendorf even before the change of PR, and then Mr. Fleming prepares a petition for approval of wrongful death settlement and an order. And that order says that there's going to be $166,000 in attorney's fees, which is the standard percentage. But that's not what happened. It also has in there, on the nose, $11,500 in expenses, which are completely fraudulent. Didn't exist. And what Mr. Fleming's own staff revealed is that in the Satterfield case, every step of the way, normally when they're preparing the disbursement sheets, they're getting all the receipts from the expenses, depositions, travel, mediator expenses, all that. She's getting them all together and she's itemizing them and doing all the math for that disbursement sheet for the client to sign. And instead, no, stop. This is the numbers I want you to put down. That was Mr. Fleming doing that, not Alex Murdaugh. That's plea exhibit 9, Your Honor. January 7th, 2019, they get Chad Westendorf to sign a disbursement statement. Again, it's got those fraudulent expenses of $11,500 on there. This time it does indicate that the attorney's fee is $50,000. Again, cutting the fee, but never telling anybody, telling Mr. Westendorf, hey, let your clients know what a great attorney I am. I'm cutting my fee in half, or less than half. Out of the goodness of my heart. Never says that. What does that tell you, Your Honor? Why would somebody do that and not let the people who are supposedly benefiting from that know? The only reason you're doing that is because you're creating a delta for your co-conspirator to steal. Mr. Fleming, when that check gets cut, Mr. Westendorf's like, what do I do, man? Tell me what I need to do. And he says, I'll handle the disbursement. Mr. Fleming does. I'm going to pay some medical expenses, which he never does. Absolutely never does. January 17th, 2019, just a week later or so. That first money has come in. It's in Corey Fleming's trust account. And this is the first evidence where we see Mr. Fleming be like, yeah, that's a lot of money. I think I'll just go down and take some of it. And he goes down to a staff member and says, cut me an $8,000 check made out to me from the trust account of money belonging to this family and say it's expenses for the case. They're completely fraudulent. We can look at Mr. Fleming's accounts. He may not remember why he did it, but we can see why he did it. Bank records tell a story. And we can see the balance in his account and how low it was. And we can see that money come in and it immediately goes to pay a mortgage and other personal expenses. Needed the money, had their money, and just walked down to a staffer's desk and said, cut me a check. And stole it. Ultimately, there's a mediation. Mr. Fleming is there, and Mr. Murdaugh is there, and ultimately they collude during the course of that. And Mr. Murdaugh is like, Bo, I got to get me something out of this. I got to get me something out of this, Corey. They accept an offer, settlement offer for $3.8 million. Does Mr. Fleming tell this family about such a momentous event? No. Does he try to communicate with them? No. Does he tell them, oh, I got y'all $3.8 million. I can take $1.4 million in fees from that, and I'm going to cut it in half out of the goodness of my heart. Does he do that? No. Why? Because he is creating that delta for his co-conspirator. Because they have the patsy in there so that they can get the scheme done. And they tell Mr. Westendorf again, we got it. Mr. Fleming says to Mr. Westendorf, I'll take care of the disbursements. $3.8 million come in. That's a big day. And Mr. Fleming doesn't wait a moment. Because on March 26th, he goes right back down to his staffer and says, hey, cut me a check for $8,500 for expenses in the estate of Gloria Satterfield, which are completely fraudulent. Couldn't wait one day. Let me go ahead and put $8,500 in my pocket. And again, we can look in his account and see how low his balance was, and we can see immediately the vast majority of that money he has to make a payment of taxes. Again, there's no illusion about the motive here. He was broke and he needed the money, so he just stole it from this family because he had it in his trust account. Well, they got $3.8 million. And again, if you have any illusions about Mr. Fleming believing that when he cut those checks to Forge, that $2.9 million check, which is the next check that he cut to the single word Forge, that he really thought that every dime of that money was going to this family, well, the emails prove otherwise. And these are crucial, Your Honor, State's Exhibits 13 and 14. Because the adjuster at Nautilus is like, I don't understand. What? Tell me how to cut this check. Is he doing a structure or not? Or does he want a single check? We need to know, because if he's going to do a structure, he has to do it this way. And Mr. Grantland sends it to Mr. Fleming, says, what do you want me to tell him? And Mr. Fleming's like, well, says some things. He's like, well, I got to check with Forge, which is a lie, because he's not dealing with real Forge at all. And they don't have an answer. So, again, Mr. Grantland sends the same question that the adjuster from Nautilus is saying, how are we cutting this check? This is the email. I need some clarification here. If he has a structure, don't we need to wait for information on the structure? Is he wanting us to fund the structure? Or is he funding the structure? If he wants us to fund the structure, it must go through Ringler. If he doesn't want us to fund the structure, does he want the funds to consist of a single check in the amount of $3.8 million payable to Chad Westendorf as PR? And the Nautilus attorney forwards that to Fleming and says, let me know what I need to tell her. And eventually, on April 1st, 2019, Mr. Fleming says, okay, standard check. Chad Westendorf as PR and MK&F as attorneys. There was no structure, and Mr. Fleming knew. Aside from the fact that's not how it works. He couldn't take the money directly. You can't do a structure in the traditional sense that way. These emails prove it. He tells them standard check. And of course, that check is cut to his trust account. And May 9th, 2019, Mr. Fleming tells the Nautilus attorney, you don't have to come to the hearing. And then, Your Honor, this is State's Plea Exhibit 18, and this is a crucial thing as well that refutes Mr. Fleming's claim that he was only doing 58 miles per hour. Because again, his staffer starts to prepare a disbursement sheet, and she's searching for legitimate expenses, and she puts on there that there were disbursements to Forge for Lloyd's of London of $403,500, and there's disbursements to Nautilus of $2.9 million in change, and also puts on there the fees. And Mr. Fleming, not Mr. Murdaugh, Mr. Fleming goes down and tells his staffer, no, stop, don't do it like that. Put these numbers down. Without any support, just tells her, no, I want these numbers. And that's in Plea Exhibit 19. And what's crucial about that, Your Honor, is that any reference to Forge is removed. In the one they actually give to Chad Westendorf. It's removed. And what's also crucial about that disbursement statement, Your Honor, State's Plea Exhibit 19 that they give to Chad Westendorf to sign is that it's got the full fee, collective fee between the two recoveries of $1.4 million on there. It lists that they're taking the full fee. That's what he tells the PR. He doesn't tell the PR, oh, by the way, out of the goodness of my heart, please tell the boys, I'm such a great lawyer. I'm so generous. $600,000 is enough for me. Cut it in half. He doesn't do that. No, he puts the entire fee on that. And why does he do that? He does that to create the delta for his co-conspirator to get his half of the fee split. There's no other reasonable explanation, Your Honor. Particularly when you look at the entirety of the course of conduct of these two men together. So Mr. Fleming takes his fee of $600K for Nautilus and $50 for Lloyd's, and then causes that check to be made out to Forge and has it delivered ultimately to Mr. Murdaugh. That's in May of 2019. A number of months go by, and they still have money that they've retained belonging to the Satterfields. Mind you, the Satterfields don't have a dime. The Satterfields don't even know that one solitary cent has been recovered on their behalf. They don't know any of that. And over $4 million has been recovered in their behalf, and no one has told them a thing. Certainly not Mr. Fleming, whose responsibility it was. And he can't hide behind the fact that, oh, well, I was dealing with Chad Westendorf, because he specifically didn't tell Chad Westendorf what to do, and he specifically participated in conspiring to put Chad Westendorf in there as PR as a patsy to keep the truth from coming out to these boys and this family. But still got money in the trust account. Mr. Fleming needs some walking around money. So January 2020, goes on down to a staffer and says, hey, cut me a check for $9,700 out of the Satterfield money from the trust account. Make it again payable to me. This time it's gotten so easy, he didn't even bother to try to put on their expenses for the estate or anything like that. There's just no justification. Just cut me a check out of it. $9,700. And he spent that money on personal debt. Again, if we have any illusion about what Mr. Fleming knew when he was colluding with Alex Murdaugh, or that he really thought that this money was going to the family, despite this entire course of conduct that was specifically designed to keep them from knowing a thing, there's still money in the account. 17 months go by, Your Honor. In October of 2020. And a couple things happen. The first thing is that Mr. Fleming signs a stipulation of dismissal for the case. And do they involve the Nollis attorney? Does he sign it? No. The only other person that signs it is Alex Murdaugh, the defendant himself. And concurrently with that, at the same time, the next day, October 6, 2020, he causes another check to be cut from his trust account made out to the single word Forge for $118,000 and has that delivered to Alex. Now, what's interesting, Your Honor, is that when we look at that $118,000, and then actually there was still $113,000 that was remaining in his trust account when all of this stuff came to light, it totals $231,000, which in their sentencing memorandum, they admit, they attribute that to Mr. Fleming. But how in the world can they attribute that $118,000 in October 2020 when he disperses that to Alex to Forge, and they sign that stipulation of dismissal with the defendant himself? How can he say that he knew that that forged check was bad, but not the other forged checks? The whole thing stinks to high heaven. The whole thing is done underhanded. The whole thing is done to prevent the system from knowing what was going on and to prevent this family from knowing what was going on. It was designed that way, and he was part and central to it, crucial to it, from the very beginning. Mr. Fleming might try to tell you, or his counsel, that when everything came to light, he was appalled. And eventually, as everything came to light, and actually after requests were made, or demands were made, disgorged his fee. Well, Your Honor, you don't get to rob a bank, run down the road, and the police catch you, and say, oh, here's the money back, we're cool, right? It's not how it works. And what he didn't do was say, oh yeah, by the way, I've been stealing checks from these accounts for almost a decade. He didn't come clean with that. It took the state grand jury to catch him red-handed for him to finally recognize that he was caught. And he could no longer claim to be, like so many other people, yet another poor, unfortunate victim of Alex Murdaugh. No, he was the co-conspirator. Your Honor, when we total up the losses attributed directly to Mr. Fleming's conduct in this case, between the Satterfields and the Pinckneys, that total is $3,725,203.85. everything about this case and how it was done shows you that his Johnny-come-lately mitigating, I'll only admit to what, the very minimum, I'm only was doing 58 miles an hour, everything about this course of conduct refutes that. Aside from, Your Honor, just good old plain common sense. Common sense about how this was done. Your Honor, I'd like at this time, if it's acceptable to the court, to let some of the victims address the court, and then I'll have a few more comments before I will yield to the defense presentation. And I will also request the opportunity to speak after the defense presentation to address any issues they may raise. But at this time...
Very good. Before you do that, let's all just take a moment to
yes, sir.
Stretch for a moment. Everybody will take a moment. Stand. Came from St. George. We were in Barnwell. I thought the reporter said she was coming down last night. Was she?
Penny?
Yeah.
Yes, I don't know. I just
So
received that information.
she was leaving Barnwell yesterday to come here. And notice. But you Sure.
He put something on me.
Okay, we'll come to order.
Thank you, Your Honor. With the court's permission, I believe our first victim who would like to address the court is Mr. Tony Satterfield.
Okay.
My name is Tony Satterfield. So first, I just want to say this is actually a life lesson to everybody. You know, a lot of times, we think our actions do not affect other people, but they do, bad and good.
Mr. Satterfield, if you will address your comments to me.
Oh, I'm sorry.
Yes, sir.
Same thing I'd like to say is that my answer still stands. I still radio Mr. Fleming. And as far as the sentencing goes, that's left up to you, Your Honor. That's why, you're in the situation to give that, not myself. And the main thing, I know I'm going to get asked, well, what do you think? How do you think it went? me personally, my honest answer, I don't care. I just want God's name to get the glory for it. And I just want, His name to be known.
All right, thank you.
Junior Adwin, Gloria's sister.
Good morning.
First of all, I would like to say that our family, of course, was affected in a tremendous way that hurt us deeply, because we not only trusted the system, we thought what was family to us. And yes, Mr. Fleming did wrong, and he admitted what he done. And yes, he should be punished for what he's done. But we do forgive. As a Christian family, we believe in forgiving. But it still does not take away the hurt that he caused us. And also, we feel like Gloria did not die in vain, because her case actually brought out a lot of other corruption and dishonest deeds that were done to other people. And we feel like that it is being served now. Things are coming to light that should have been brought to light a long time ago. And I want to thank the state for all the work that y'all have done to bring everything to light. And Mr. Wardage, you've done a fantastic job this morning, bringing out everything and actually simplifying a lot of stuff. And thank you very much. Judge, thank you so much. We trust in you and your honor that you will make the right decision in your sentencing. And again, we do forgive Mr. Fleming.
Thank you.
And Eric and Ronnie also.
Judge Newman, my name is Eric Bland, and I have the honor of speaking on behalf of the Satterfields.
Yes, sir.
I also have the honor of speaking as a lawyer of 35 years on behalf of other lawyers. Lawyers who are overwhelmingly honest and do good by their clients. The license we have is a sacred trust. It's a trust that we have to help our clients. It's not a ticket or a license for us to take from our clients. And, it's natural that we want to dislike criminals. We want to dislike people like Mr. Fleming. But you're going to hear from a courtroom of people that he's a nice guy. But unfortunately, nice guys sometimes do criminal activity. And so you have to balance today not only the sentencing of a man, but sentencing the crime. Because our profession, a profession that I love, a profession that you love and dedicated your life to, has been stained. And you understand that when things like this happen, when lawyers take money from their clients, especially in this case when it's millions and millions of dollars, that the jokes multiply by 10. I've never liked lawyer jokes. I don't like people mocking lawyers. I don't like the nasty things that sometimes the people say. But one criminal activity in this type of case germinates and hurts our profession for a long, long time. Now, I think it's important that you do understand that Mr. Fleming knew exactly what he was doing. He is a plaintiff's lawyer. He has settled plaintiff cases before. And in this particular case, he worked with the party he was making a claim against. It's impossible to get your arms around that. He didn't have client permission to do that. He never had a fee agreement to do what he did with the client. We know, and Your Honor knows, that contingency fee agreements have to be in writing. There was no contingency fee agreement. There was no joint sharing agreement with Mr. Murdaugh, even though he couldn't do it to begin with, to disclose to the client. There were no disclosures at all to the client. He met Tony Satterfield as the PR one time. There never was any communication. I've been suing lawyers for probably 30 of my 35 years. I have never seen every single dollar taken from a settlement. You see sometimes that it's, a portion of it. But in this case, they took every single dollar and never communicated with Tony Satterfield, never communicated with Brian Harriet, his brother. They recovered millions of dollars. They should have been applauded for recovering that on behalf of Gloria Satterfield. You're going to hear that Mr. Fleming said he won't use the word victim like he used for the last 2 years, where he said that he was a victim just like everybody else. But you're going to hear kind of off words that are close, maybe a first cousin of victim. You're going to say he didn't understand what was going on. Sure he did. if you're going to do a structure, Your Honor knows that you have to have insurance policies that represent that structure. Your Honor knows that when you have two beneficiaries of that structure, there would be two separate policy numbers, one for Tony, one for Brian. Your Honor knows that if you're going to send a check to the structured insurance company, you got to allocate. You can't just send a check for $2.9 million to an insurance company and not have any reference on the check that this amount is for Brian and this amount is for Tony, and it needs to be deposited in this account and applied to that insurance policy number. None of that was done. Mr. Fleming sent the check without a cover letter. No letter to Forge to say, hey, this is how it's allocated. It was sent to a P.O. box in Hampton, South Carolina. Every plaintiff lawyer knows that Forge is in Columbia, South Carolina, and Atlanta, Georgia, not in some P.O. box. More importantly, the three checks that Mr. Waters described were signed on the back by Alex Murdaugh himself. It says, DBA, Alex Murdaugh, DBA Forge. Hey, that would give it away, right away, that he was not doing a regular structure. This is a case, Your Honor, that was really two letters that were sent. And, magically, $4.3 million was produced. A tremendous amount of money. Not that Gloria or any other person isn't worth that. But that is a very large settlement. A settlement that would probably be 3 times larger than most other counties in our state. And Mr. Fleming took $11,500 in expenses in a case that there was no filing fees, in a case that there was no depositions, in a case that there was no experts. He had a signed disbursement sheet in May of 2019, signed by a judge, just like you. And when you sign an order, we have to follow it. But he took that order, and he never filed it with the clerk of court, despite getting a letter from the insurance company that said, before you disperse on that check, make sure you get a signed order and file it. But what did he do? He didn't file it. What did he do? He went into the chambers of Judge Carmen Mullen down here, and he told her, look, we've made a decision to change the caption on the case. Instead of it going to be the estate of Gloria Satterfield decedent versus Alex Murdaugh, we've decided to take Mr. Murdaugh's name off the caption. Now, I can't do that without Your Honor's permission. But that was done without a court order. And then they took off Gloria Satterfield estate and decedent to make it look like she wasn't even dead at all. And what did they do? They came back after they got that signed order, after they told Judge Carmen Mullen, this is how we're going to disperse it. There was no reference that they were going to send $2.9 million of the $3.8 million to Forge. They were going to disperse it to Brian and Tony. What did they do? They just totally disregarded that order and started cutting checks, a check cutting party on May 14th. No court permission. If I'm going to deviate from the order you signed from the disbursement sheet, I better come back before Your Honor and do that. No permission from the court was done. Nothing. No communication with these clients. This young man here, who's a vulnerable adult, who's in his 30s, lost his mother. Alex Murdaugh and Corey Fleming knew that his trailer was being foreclosed on, and he didn't have the money. And they're sitting on $4.3 million of their money while he's getting pushed down on the street and loses his mother's trailer. That was all she had. That was all she had. What happens? He keeps money in his trust account. Judge Mullen signed an order that said, you disperse every single penny in your trust account. As Mr. Woodard said, he kept it for 18 months in a case that was over with. In a case that he went before Judge Mullen and said in May, I need $105,000 of additional expenses that we spent. That's going to be dispersed. Again, in a case that No lawsuit, no depositions, no expert witnesses, and it was $105,000, not $105,172.27. It was just blatant thievery in open eyes of everybody except the two most important people that we work for, the clients. And what happens? Like Mr. Waters said, on October 12th of 2020, 17 months later, they decide we're going to cut some more checks. And you know what? We better get this case off the docket. So Mr. Fleming and Mr. Murdaugh decide to sign a stipulation of dismissal. Mr. Murdaugh had a lawyer, John Grantland, who represented an orderless insurance company. He wasn't contacted. Mr. Fleming knew that there was a lawyer involved, and they dismissed the case. Yet he sits on another $113,000 for another year, all the way up to the fall of 21, when he finally was caught, when I finally surfaced on September 7th with my partner, Ronnie Richter. Now, I will say this. Of all the defendants that we got money for, and we can announce that we've recovered more than $7.5 billion for the Satterfields from a number of sources. Mr. Fleming was the first to come forward in the fall of 21. He did disgorge himself of the $680,000. His insurance company did pay the full value of his policy. He did finally disperse the remaining $113,000 in his trust account to my clients, and there was additional monies paid by his law firm. But the last thing I want to add, Your Honor, is he fought these charges. He wrote a letter to the Georgia Bar. Now, unlike our South Carolina bar proceedings, the Georgia bar proceedings are over. I was a complaining party because whenever I bring a claim against a lawyer for malfeasance or theft, it's my duty to notify the bar, and so I notified South Carolina Bar and notified Georgia Bar. So I'm part of the process in Georgia. They want to hear from the complaining party. So when Mr. Fleming filed his response to the Georgia Bar complaint, I got it. It was a 57-page response that he did under oath. Swore to tell the truth, just like he's going to do when he stands before you today. You know what he told the Georgia Bar? I was a victim of Alex Murdaugh's theft. I had no idea what he was doing. I was duped just like everybody else. I didn't understand how to do the structure of Forge. Mr. Waters shared with you that February 2017 letter. It was crystal clear. And he'd already done structures, but even if you haven't done structures, it says you can never get the check as the settling plaintiff lawyer. It's got to go from the paying insurance company to the annuity insurance company that's going to issue the structure. He already got the checks. Like Mr. Waters said, Forge doesn't get money. They're a broker. You don't send money to Forge. It goes to an insurance company. But in that 57-page response, he says, I had no idea what was going on. He didn't, you know what he said? I stole from my law partners. I didn't steal from the clients. When I stole those 3 checks of the $9,500, the $8,500, and the $9,000, I was stealing from my law partners. By the way, Judge, you read the rules of professional conduct, we don't have a license to steal from our law partners either. That's another no-no. So, I know you're a just judge. I watched you. I've watched you your entire career. I know how much you care about what our profession. I certainly know how much you care about our state. And this whole Murdaugh, Fleming, Lafitte debacle has stained our state. And I'm going to leave with saying one thing. The hand of one is the hand of all. And Mr. Fleming is pleading guilty to every single charge, which means every single element of every single crime and every single fact that Mr. Waters has announced form the basis of those. So I ask you to do your duty, to look at this as these are state court independent charges, not to look at, well, he's been sentenced in federal court, So that kind of takes care of it. These are claims that our citizens, the state of South Carolina, brought through a grand jury, advanced with our dollars through the South Carolina Attorney General. And I'm confident that at the end, you will give that proportionate, just sentence that deals with retribution to punish Mr. Fleming appropriately, but not overly so. Deterrence to tell me and every other lawyer, you cannot steal from your clients. Your duties are to your clients, not to yourself. Thank you.
Thank you.
Your Honor, I think our final victim presentation before I conclude my initial remarks comes from Mr. Bamberg, who again represents Pamela Pinckney. And I think it's important to point out that while there has been a resolution in federal court, that was only on indicted Satterfield conduct because of the statute of limitations there. And I know that Mr. Bamberg will address, of course, that we are here today for the first time for accountability as it relates to Ms. Pinckney alone. But Mr. Bamberg, I'll turn it over to you.
Thank you, Your Honor.
Yes, sir.
Creighton is correct. Attorney Waters is correct. On behalf of Ms. Pinckney, she wanted to be here, but she had a procedure on Monday, a medical procedure, and she's been dealing with a lot of pain since. So I'm here on her behalf, and that really speaks to the type of people who were victimized. We had to sit through a federal case through the United States of America's court system and hear about things that were done to the Satterfields. And Ms. Pinckney, her family supports the Satterfields. What happened to Ms. Pinckney, what Mr. Fleming did to Ms. Pinckney was mentioned in the federal case. However, due to statute of limitations, she was not able to seek justice, criminal justice through that. That's what today is for. It's her first opportunity after well over a decade. Your Honor, I want you to understand a little bit about what Ms. Pinckney went through. When we think about white-collar crime, a lot of times people talk about it as though it is victim bliss, that it just involves the almighty dollar, and that's not the case. This was a horrendous accident. Not only did Ms. Pinckney shatter most of the bones in her body, there was a very extensive recovery process for her. But she had to deal with injuries to other people that she cared about. For example, her niece, who in addition to numerous physical injuries, lost the vision of one of her eyes. And her son, Hakeem Pinckney. And Hakeem, Ms. Pinckney poured her soul into that young man. And he lost his hearing at 3 years old. He struggled with that. And she never gave up on him. She poured into him. He ended up graduating from the South Carolina School for the Deaf and Blind. And shortly after graduating, he had all these dreams and ambitions. And during that accident, that fateful day, this young man was rendered quadriplegic. He was unable to move anything below his neck. He was on a ventilator to breathe from him. He relied on an electric machine to breathe from him. And because he couldn't move, he couldn't sign language, and therefore he could not verbally communicate. And she never gave up on him. Hakeem died, and it was very tragic. His ventilator was found unplugged. So, and it's hard not to get teary-eyed when you think about what he went through, but here's a young man who cannot hear, he cannot speak, he cannot move, and now he cannot breathe, and he can't tell anybody. He became a prisoner of his own body. And Ms. Pinckney was aware that that is how her son died. And instead of being a supportive lawyer, instead of showing compassion and care, empathy or sympathy, he could have said to this woman, I am so sorry for what you went through. I want to own up to the fact that I took some of your money. No, he didn't. In fact, they took the money and they flew to the College World Series to watch baseball. Meanwhile, this woman is still recovering. She's still dealing with the loss of her son. And no one cared. And I've said this before, Ms. Pinckney, myself, the Pinckney family, everyone believes that Mr. Fleming regrets everything that he did, not just to them, but to the Satterfield family over a decade later. Nobody doubts that he regrets it. It's hard to not regret your decisions when you're sitting there. I think everybody regrets that except complete sociopaths. We do not believe that he is remorseful for what he did. And there is a difference between I regret getting caught and getting in trouble and true remorse for what I did to you. When we hear these numbers, Your Honor, and we hear numbers like $500,000, we hear numbers like $3 million, we hear about total amount of money stolen, we have to remember that where we come from, and myself, Ms. Pinckney, that I'm talking about geographically, where we live, we're $8,000 check, $9,600 check. Yes, for privileged attorneys and others who either have been very blessed, very successful, or work very hard to get there, it may not sound like a lot of money when you hear about $4 million get taken. Minimum wage in our state, Your Honor, $15,850 if you're making minimum wage. That's how much you earn working for a year. Some of the money that Ms. Pinckney lost, she would have to work over half a year to earn and then pay taxes on it. This is not a small amount of money. This is not a victimless crime. Your Honor, we trust the system. And I echo much of what Eric Bland said, that this was a black eye to attorneys, it was a black eye to the legal profession, it was a black eye to our state. But it was a dagger in the heart of the clients who trusted their lawyers. Mr. Fleming knew he wasn't supposed to do it. We firmly believe, and I've had in-depth conversations with Ms. Pinckney about this, it wasn't until the federal government came, and now there was this window of opportunity to possibly serve a sentence in federal court, that Mr. Fleming was then willing to say, yes, I did X, Y, Z. Up to that, there was no, yes, Ms. Pinckney, I took your money. That wasn't represented to the ODC ethics, as you heard Attorney Bland reference. It was deny, deny, deny. And one of the most difficult things for Ms. Pinckney and every other victim is having to know that you are truly a victim of bad acts from bad actors, and then hear those same bad actors who took bad acts say that they're a victim. It's demeaning, it reopens old wounds, and it's highly offensive. And in the world of white-collar crime, Your Honor, if we talk about Wall Street, it's not necessarily people stealing your money and you willingly give it to the investment bankers. No one willingly gave Corey Fleming their money. He deceived them. He took it. You know, and I know that there will be folks who will speak very positively about him. And we have no doubts that to a lot of people in his life and over the course of his life, Your Honor, he was an amazing person to them. He did do wonderful things to them. He was very giving to them. But he's not here today sitting in judgment of Your Honor for how good he was to everyone else. He's sitting in judgment for pleading guilty, element for element, charge for charge, to how bad he was to Ms. Pinckney and the Satterfields. And we would ask that Your Honor take all of that into consideration. This is their one chance after over a decade to get justice, Your Honor. And we ask that this court impose a sentence that is not only sufficient to, again, punish Corey Fleming. He's got a federal sentence again, but it has nothing to do with Ms. Pinckney. He has not been punished for that. We ask that you sentence firmly to not only punish him for that, but to also deter not just lawyers, but anybody who owes a fiduciary duty and people rely on you. Don't steal from them. We're not expecting people to be perfect, but we are expecting you to be a decent human being. And if you're a lawyer and you take that oath that we all have to take, that you take that oath seriously. And it doesn't matter whether you personally have hard financial times or not. The saddest part, as an attorney who's gotten to know Ms. Pinckney, Your Honor, is knowing that even with the horrible death of her son, even with her own broken bones, her own medical bills, is that Corey Fleming needed money, Your Honor, and asked her. I guarantee you she would have gave it to him. That is the type of person Ms. Pinckney is, and that is who we victimized, Your Honor. Thank you so much for your time.
Thank you.
Your Honor, I just have a few more brief comments, and then I will yield to the defense for their presentation. Again, would request the opportunity to speak and reply after they have presented. Mr. Bamberg touched on this, and I know Your Honor has been presented a lot of letters, and I know that there's support out in the courtroom for people who have known Mr. Fleming, and I'm sorry. I'm sorry to them because they've been victimized by this too, because they have to be here. And they're put in this position. And I'm sorry that they have to go through this because I have a job to do. These people on our team have a job to do. The law enforcement officers here have a job to do. And the reality is that to be a con man, it depends on trust. It depends on reputation. It depends on the inherent credibility that comes with having a law license on your wall. It doesn't work otherwise. It depends on someone who doesn't have a prior record, which Mr. Fleming does. That's how con men work. That inherent trust and reputation is what they tread upon for this scheme. It doesn't work without all these good things that people are going to say that they believed about Mr. Fleming. It's the only way a con man can succeed, is if people trust him. And they did. And he betrayed them. You might hear a little bit about the process, and you may hear essentially that the state, the Attorney General, the State Law Enforcement Division are being unreasonable because we refuse to accept and just check the box that Mr. Fleming was only doing 58. Instead, insisting, because of the hard work that was done by all these folks, to really dig deep and uncover the truth. The truth matters, Your Honor. The truth about what happened to the system matters. The fact that he was doing 90 miles an hour matters. It matters. It's not enough to just say, I did 58, and we'd say, okay, that's fine, we're done here. What really happened matters. When it affects the integrity of the system, when it was abuse of the system, of the very courtroom in which we are in right now. Your Honor, independent accountability for his abuse of his state law licenses, state court actions, is warranted in this case. Consecutive time is warranted. Consecutive time is warranted for the extent of the reality of what Mr. Fleming did to the Satterfields, exposed in this courtroom, the 90 miles an hour. Independent accountability is warranted for that, above and beyond whatever was before. I'll give Mr. Fleming credit for pleading guilty, but he doesn't get credit for the delta, for the difference between 58 and 90 miles an hour. And his inability and refusal to admit to that, to only admitting to the most mitigating version of events that he can no longer deny because he's caught red-handed, that only should get so much credit, Your Honor, and there needs to be independent accountability for the truth of what happened to the Satterfields above and beyond any other proceeding that has nothing to do with what happened here, or what this proceeding is. Independent accountability is warranted for Pamela Pinckney, who, as Mr. Bamberg said, has convictions relating to the conduct victimizing her in this court. And while you may hear that in another proceeding they rolled that into a PSR, that's not the same thing, and we don't even get that. I don't know what's in that thing. It doesn't matter though. A lawyer should not get one-stop shopping for victimizing multiple clients over the course of a decade. It's not buy one, get one free. There should be independent accountability here today, consecutive accountability for Ms. Pinckney. He should not get buy one, get one free. And independent accountability is again warranted for the state judicial system itself. They must defend itself and have its own independent accountability and not allow someone, when the state is unhappy with 58 miles an hour, to just make a deal and that be the end of it. I ask Your Honor for consecutive sentencing. I ask Your Honor that even if you run sentencing for the Satterfields concurrent to anything else that happened, that any sentence for the Pinckneys be consecutive. I ask Your Honor not to let Mr. Fleming, who I think we have established has not completely come clean with the reality of his behavior and only admitted to what he's admitting to now because he got caught red-handed.
What is his exposure for in the Pinckney case and the Satterfield case?
Stand by, Your Honor. So the total exposure between the two is 195 years and fines up to over to $8,090,863.90 plus discretionary fines. Your Honor, if we look at the Satterfield crimes, count 10 is a criminal conspiracy, which is 0 to 5. We have 3 counts of insurance fraud, $50,000 or more, which is 0 to 10, plus fines of $20,000 to $100,000. Counts 13, 17, 21, and 30 are breach of trust with fraudulent intent, $10,000 or more, which are 0 to 10, plus fine in the discretion of the court. Counts 14, 18, and 22, value of money laundering, value $100,000 or more, carry a potential sentence of up to 20 years, Your Honor, and a fine not to exceed and/or a fine not to exceed $250,000. Counts 23, 25, and 27 are breach of trust with fraudulent intent, value $2,000 to $10,000. That's 0 to 5 plus fine in the discretion. Counts 24, 26, and 28, 3 counts of money laundering, value $300 to $20,000, which is 0 to 5, and/or fine not to exceed $250,000 or twice the value of the transactions. And then count 29 is computer crime, value more than $10,000, which is a 0 to 5, and/or fine not more than $50,000. Your Honor, that is the Satterfield case. For the Pinckney case, 2022 GS 4702, again, both of these indicted by the state grand jury back in early 2022. We have counts 5 and 9, which are breach of trust with fraudulent intent, $2,000 to $10,000, which are 0 to 5 plus fine in the discretion, or fine in the discretion. Counts.
You say 0 to
0 to 5 or fine in the discretion for that one, Your Honor. Count 6, breach of trust, $2,000 or less. That's actually a 30-day offense, Your Honor, or a fine not more than $1,000. That would have been one of the crosswind checks, which was like $1,400. Count 7, which is criminal conspiracy, that's 0 to 5. And count 8, breach of trust, $10,000 or more, which is 0 to 10, or fine at your discretion. Again, the state would submit that no matter how you stack them, even if you run certain ones together, that there needs to be independent consecutive accountability from one to the other. And that there needs at a minimum to be a lead sentence for the Satterfields and a consecutive lead sentence for the Pinkeys. So that Mr. Fleming, for decades, almost a decade's worth of conduct, doesn't get buy one, get one free. Thank you, Your Honor.
All right.
You're consuming the Hidden Killers podcast.
Want more? Start binging on all of our true crime podcasts right now through Apple Podcasts and get an ad-free experience when you sign up to be a True Crime Today Premium Plus member exclusively on Apple Podcasts.
More of the Hidden Killers podcast dropping soon.
Press subscribe now.